Story this evening is our colleague Yash Jain. The Company Law Tribunal has dismissed Cyrus Mistry's petition, which claimed that minority shareholders in Tata Sons were being oppressed. Yash has been following this story. Yash, take us through the judgment and the background of this case.
Well, something which certainly can be viewed as a major blow to the Mistry camp. The NCLT, or the National Company Law Tribunal, today in its order denied granting waiver to the maintainability or the eligibility clause of the company petition which was filed by Cyrus Mistry against Tata Sons. Now, if you remember, on March 6th, the NCLT had also dismissed this very company petition, calling it not maintainable under Section 241 and 242 of the Companies Act. And this waiver plea was the only way through which this company petition could walk back into NCLT. But today's order in terms of denial of this waiver clearly dismisses the company petition at NCLT. Now, if you look at the arguments also, Tata Sons Counsel Abhishek Manu Singhvi made a strong case against this waiver petition. He said that a waiver can only be granted if the waiver plea is filed with the original company petition and not midway when the company petition has been called not fit under the Companies Act. He also said that the waiver can only be granted if the petitioner is remediless, which is not the case in this particular situation, as Cyrus Mistry has the option of moving to NCLT or even the Supreme Court if NCLT does not give any order. So clearly that argument also does not fit here. Now, today's particular judgment also marks the end to the journey of this particular case at NCLT. But do remember, Cyrus Mistry will have the option to move NCLT and Supreme Court with the same case of operation and mismanagement against Tata Sons.
All right, Yash, thanks very much for joining us. Now, to take this conversation further, we're now joined by Abhishek Manu Singhvi, the counsel for Tata Sons. Mr. Singhvi, thanks very much for joining us. As our colleague Yash was just pointing out there, the waiver petition has been dismissed by the Bombay High Court. I'm just looking at the release that's been put out by the Tatas, and Mr. F. N. Subedar, the Chief Operating Officer of Tata Sons, says, "We hope this brings to an end a vexatious campaign against the company, the Tata Trust and Mr. Ratan Tata." Do you believe that this could perhaps be the end as far as the legal battle is concerned, because Cyrus Mistry does have the option of moving the NCLT?
Shereen, let me make my points in a few separate points. First of all, I meant to make it clear that many people asked me for bites when the matter was going on, including your channel, and I have scrupulously avoided giving any substantive bites till the judgment is given, since I am appearing in the matter as senior counsel. I'm quite happy that the judgment has come. The first point I want to make, Shereen, is that this is probably the fourth substantive reasoned order against Mr. Mistry. One was a denial of interim relief and interim injunction. Two was in a nature of a contempt which he tried to allege against the Tatas. Three was holding his petition itself to be non-maintainable. And four is today holding that apart from being non-maintainable, he is not entitled to waiver. The second point I wish to make, Shereen, is that, these are important corporates in their own rights, and just because Mr. Mistry is against Mr. Tata doesn't mean that he doesn't occupy an important place in the pantheon of corporates. I think this is not for me. I'm not here to give advice. I'm not appearing for him. But it's a time when, with these four long, arduous battles, they consider that they should not unnecessarily go on. But if they want to go on, they are welcome to go on. The remediless point, that's the third point I wish to make, which your correspondent made just now, is not about the NCLAT. The remediless point I made in my written submissions was about the fact that they could theoretically move a civil suit, and therefore they are not remediless in the sense that NCLAT is the only remedy they have. That was the point made.
Right.
Fourthly, I think this waiver judgment today is a precedent-setting judgment. As far as I know, this is the only judgment under the new Act, the new Companies Act. Especially in such detail, when guidelines or certain amount of light is thrown on when and how waiver can be granted. One of the points I made to the Tatas is interesting, that even if you were otherwise considering waiver, why should you grant waiver when the principal protagonist is actually a respondent 11, Mr. Mistry? The petitioner companies who are petitioners are not really aggrieved. The aggrieved person is a respondent who has not filed no petition of his own. And incidentally, all his grievances are grievances arising in his capacity as a director, which actually run to the base of and erode the very base of the law, which says that your grievances must be oppression or mismanagement in the capacity of a shareholder, not a director. And therefore, I have not seen the judgment. I don't know what the court has held. But these and many other points in a very detailed written submission were there. I'm quite happy that a precedent-setting judgment has been laid down. Of course, the last word on this would lie with the NCLT and then with the Supreme Court, should Mr. Mistry choose to go upwards. But, you know, this is his choice. Otherwise, it's a very unnecessary corporate battle, unseemly and ungainly. And I think, you know, it need not be merely an ego battle, which it appears to have become, at least for the petitioner and the appellant.
You said that this is an unnecessary battle, and you hope that this will, in fact, be the end of the battle. You've also pointed out that this, in fact, is a precedent-setting judgment, Mr. Singhvi. But be that as it may, can Mr. Mistry choose to go to the Supreme Court before he goes to the NCLT? Can he supersede the NCLT and approach the Supreme Court, should he choose to?
No, there is a clear statutory appeal provided in the Act. An appeal which is statutory in nature from the NCLT to the NCLAT. And there is no reason evident in this case why he should be allowed to bypass that appeal or leapfrog from the NCLT straight to the Supreme Court. I don't see any reason why that should be done, but of course it's up to him to choose what he wants to do.
Right. Mr. Singhvi, since you mentioned that this was a precedent-setting judgment for Corporate India, and Corporate India has been watching this bitter boardroom battle very, very closely, what are the key takeaways or the key headlines that one should take away from this, sir?
I think if one really wants to educate oneself, one must read the nitty-gritty, because both God and the devil lie in the details. There are very useful written submissions filed that will throw a lot of light on this area of law, which is being decided for the first time. I am sure some of those written submissions have been accepted, which is why the judgment is in our favor, and the judgment will throw further light. In a nutshell, Shereen, without taking too long and being too technical, I think it's vital and important at this level because A, it tells you that waiver is not a walk-in, walk-on, walk-out simple procedure. Waiver is not intended to nullify the basic bar to maintainability. See, Shereen, the object of this maintainability bar is to say that, look, we know that some companies would have some oppressive practices, some mismanagement, but we take a policy decision as a legislature to bar anybody and everybody from coming to the door of the company law board unless they have at least 10%. And secondly, they say that that 10%, if you have less than 10, you may in rare cases waive it. But the waiver, which is a proviso to the main bar, cannot swallow up the bar. You can't create a bar and then swallow it up by allowing waiver as usual. The third aspect, which is precedent setting, I'm sure the judgment will bear it out, is that what are the kind of cases where you may grant waiver? One of them obviously is where you have sought waiver from the inception. Here Mr. Mistry's case was that there is no waiver required. The petition itself is maintainable. Much after that he says, no, well, in the alternative, if it is not maintainable, then give me waiver. The fourth issue here would be that Mr. Mistry admittedly is aggrieved only in the capacity of a director. He virtually holds no shares. He's not a petitioner. In fact, he's respondent 11. So should you at all exert yourself to waive the mandatory 10% requirements when the persons who are seeking waiver are not the shareholders but really de facto de jure the director respondent 11? The fifth reason why this is precedent setting is that all the allegations of Mr. Mistry related not to the respondent company but to independent Tata companies. Now there's a whole respectable line of law that the allegations of oppression and mismanagement relate to the main company against which you filed the petition. Here the petition is filed against X, but all the allegations are against A, B, C, D, E, F, which are big independent public listed companies like Tata Motors, like Tata Steel, etc., etc. So it's a kind of a proxy litigation to attack companies other than the company which is respondent number one. And there are many other issues of law,
Abhishek Manu,
the guidelines.
I'm sure they are, sir, but thank you very much for taking us through the order today and the implications of this for Corporate India, not just for this particular matter. But thanks very much, Mr. Singhvi, for joining us here on CNBC TV 18. Setback.